Get a grip, then get a chip. Won't even trip. Though my cup was running over, I took only a sip. Stay hippin', then I'm hopping, I'm dropping. It won't be flopping, no shock. That whatever I'm selling, you will be copping. He was the strongest, though he was the one that cried. And he chose to kill his brother because he was from that side. And why? He chose this son because this one had pride. And instead of the narrow road, he chose the one that's wide. Sometimes the one that won was the one that tried. And the one who pulled the gun was the one that died. Looking good, a good look is the one that's fine. If I had to pick, fly would be the one that's mine. G-O-D, in the place to be. Attendee, Hard Knocks University. And since kindergarten, they've been hiding the knowledge. Homeboy is self-taught, never went to college. I'm brown skinned, I'm from Pelon. Rainy alarm, then I remain cool and calm. Reading Psalm, fire like napalm bomb. We are in the information age on Do You Know Your Value page. Me, I be the content creator with force like Darth Vader. Back on the track with the facts and all that. One path is the way that I'm taking, getting closer to God in a tight situation. Tonight, we are going over the Annotated Glossary from Cracking the Code, 3rd edition, starting where we left off. So, without further ado, let us begin. Where do we leave off at, though? Okay. Where do we stop? Okay, we stopped at debt. So the next word is debtor. Debtor means any of the following. A person having an interest other than a security interest or other lien in the collateral, whether or not the person is an obligor. B, a seller of accounts, shadow paper, payment intangibles, or promissory notes. C, a co-signing. UCC 9102A28, a person or business that owes money or is otherwise obligated to another party. C, note, location of debtor. Note, your straw man fits in A above. A debtor is as enslaved as he is obligated. The Federal Reserve issued credit to the United States government against the all capital letters trade name of your straw man shortly after the birth of the two of you. See birth, thus incurring the obligation to repay the credit Federal Reserve notes that was loaned. However, since the straw man has no body and no means of repaying anything, the burden becomes yours as the physical recipient of all the benefits, transmitted utility benefits that have been bestowed upon you throughout your entire life in exchange for the government's use of your trade name. Your straw man's all caps trade name is referenced above as your name only because it is a piece of property that you own, but legal title is held by government before redemption. Your straw man's trade name is an artifice existing only by force of and contemplation of law, and neither references you nor identifies you. Your true name, see true name, written in accordance with the rules of English grammar, more closely identifies you, but is still only another piece of property. See appellation. Default, the omission or failure to fulfill a duty, observe a promise, discharge an obligation, or perform an agreement. In practice, omission, neglect, or failure. When a defendant in an action at law omits to plead within the time allowed him for that purpose or fails to appear on the trial, he is said to make default, and a judgment entered in the former case is technically called a judgment by default. Blacks first. See defaulter, defendant. Defaulter, one who makes default, one who misappropriates money held by him in an official or fiduciary character or fails to account for such money. Blacks first. Defendant. Defendant includes a person in the position of defendant in a cross action or counterclaim. UCC 1201-13. See action set off. Delivery. With respect to instruments, documents of title, shadow paper, or certificated securities, means voluntary transfer of possession. UCC 1201-14. A voluntary transfer of title or possession from one party to another, or legally recognized handing over of one's possessory rights to another, where actual delivery would be cumbersome or impossible. The courts will find a constructive delivery sufficient, provided the intention is clearly to transfer title. Barron's third. See note, pledge. Note, did your mother voluntarily deliver you into the warehouse, district, county? Another delivery occurs when the U.S. government accepts the document of title, birth certificate associated with the trade name. Sovereign newborn is pledged, transferred by written endorsement receiving in return a birth certificate. In other words, token. Warehouse receipt, field receipt. Warehouse receipt, field warehouse receipt as evidence of your warehouse receipt, field receipt as evidence of said delivery, pledge, deposit, transfer. The UCC authorizes your mother to do this as your representative at Section 3402. Denial, a traverse in the pleading of one party of an allegation of fact set up by the other. A defense, Black's false. Black's false. See traverse, traverser. Deposit account. Deposit account means demand time, savings, passbook, or similar account maintained with a bank. The term does not include investment property or accounts evidenced by an instrument. UCC 9102A29. Dignity in English law and honor, a title, station, or distinction of honor. Dignities are a species of incorporeal hereditaments in which a person may have a property or state. Blacks first. Number one, the state of being noble, the state of being dignified. Number two, an elevated title or position. Number three, a person holding an elevated title, a dignitary. Number four, a right to hold a title of nobility, which may be hereditary or for life. Blacks seventh. Note, an attorney's English title of nobility comes from his, her dignity. Discharge, the opposite of charge, hence to release, liberate, annul, unburden, disencumber. In the law of contracts, to cancel or unloose the obligation of a contract, to make an agreement or contract null and inoperative. Discharge is a generic term. Its principal species are rescission, release, accord and satisfaction, performance, judgment, composition, bankruptcy, merger. Blacks first. To satisfy or dismiss the obligations of contract or debt, the method by which a legal duty is extinguished. See note. Note, because of the bankruptcy of the U.S. government as memorialized in House Joint Resolution 192 of June 5th, 1933, or HJR 192, it is no longer possible to pay off extinguished debts. We used to be able to pay debts using specie, gold and silver coin, but that was declared against public policy in House Joint Resolution 192. Now we can only discharge debts by passing debt paper, Federal Reserve notes, as legal tender. Dishonor, a term applied to the non-fulfillment of commercial engagements. To dishonor a bill of exchange or promissory note is to refuse or neglect to pay it at maturity. Bouvier's eighth, and mercantile law and usage, to refuse or decline to accept a bill of exchange or to refuse or neglect to pay a bill or note at maturity. A negotiable instrument is dishonored when it is either not paid or not accepted according to its tenure, on presentment for that purpose, or without presentment where that is excused. Civil Code, California, subsection 3141. Blacks first. Tenor. By the tenor of an instrument signifies the true meaning of the matter therein contained. Cowell, Bouvier's eighth. Disputable presumption, a species of evidence that may be accepted and acted upon when there is no other evidence to uphold contention for which it stands, and when evidence is introduced supporting such contention, evidence takes place of presumption, and there is no necessity for indulging in any presumption. A rule of law to be laid down by the court which shifts to the party against whom it operates the burden of evidence merely. Black six. See note, rebuttable presumption. Presumption, legal fiction. Note, right to legal title of your straw man is a disputable, rebuttable presumption that was presumed by the U.S. government and can be successfully disputed, rebutted. No one holds a higher claim regarding title of your trade name than you, because you comprise the sole source of its existence and have acted as surety for its misadventures since you attained the age of majority and became legally responsible for your own actions. District of Columbia, a territory situated on the Potomac River and being the seat of government of the United States. It was originally 10 miles square. It was composed of a portion of Maryland and Virginia ceded by those states to the United States. But in 1846, the tract coming from Virginia was retroceded. Legally, it is neither a state nor a territory, but is made subject by the Constitution to the exclusive jurisdiction of Congress. Blacks first. A portion of the country, originally 10 miles square, which was ceded to the United States by the states of Virginia and Maryland, over which the national government has exclusive jurisdiction. Bouvier's eighth. See United States. See note. Note, a municipal corporation, incorporated February 21st, 1871. 16 Stat 419. 41st Congress, 3rd section. An act to provide a government for the District of Columbia, reorganized June 8th, 1878, 20th Stat 102, Chapter 180, 45th Congress, Second Section. An act providing a permanent form of government for the District of Columbia. Document. Document means a documented title or receipt of the type described in Subdivision 2 of Section 7201, UCC 9102A30. See note. Note, a birth certificate is a document of title for a trade name. A receipt of the kind described in Subdivision 2 of Section 7201 is a warehouse receipt. Therefore, a birth certificate, a document of title, is a warehouse receipt. See UCC 7202. Document of title. Document of title includes bill of lading, dock warrant, dock receipt, warehouse receipt, or order for delivery of goods, evidencing that the person entitled under the document has a right to receive, hold, and dispose of the document and the goods it covers. UCC 1201-15, see note title. Note, a birth certificate qualifies as a document of title because it is both a warehouse receipt and a dock receipt. Draft, an order in writing directing a person other than the maker to pay a specified sum to a named person. Drafts may or may not be negotiable instruments, depending on whether the elements of negotiability are satisfied. Draft is synonymous with bill of exchange. Barron's third. Draft means a draft as defined in Section 3104 or an item other than an instrument. This is an order. UCC 41047. An instrument is a note if it is a promise, and is a draft if it is an order. UCC 3104E. Compare site draft. Instrument. Instrument means a negotiable instrument. UCC 3104B. Drawee. Drawee means a person ordered in a draft to make payment. UCC 31032. One to whom a bill of exchange or check directs a request to pay a certain sum of money specified therein. In the typical checking account situation, the bank is the drawee. The person writing the check is the maker or drawer, and the person to whom the check is written is the payee. Barron's third. Compare acceptor. See note. Draw. Draw means a person who signs or is identified in a draft as a person ordering payment. UCC 31033. See note. Note, when you sign a check, you are the drawer, and you are ordering your bank, the drawee, to pay a sum certain to the order of the payee. Droit. Number 1, a legal right or claim. 2, the whole body of law. Blacks 7. See droit. Droit. The unification of the right of possession with the right of property, also termed jus duplicatum. Drake, Black 7. See note, compare absolute rights. Note, as with the Certificate Trust, this term also comes to us from Norman French attorneys. You have had the right of possession of your juristic strawman trade name your entire life, but you have been denied title, the name as property, because it is held in custody elsewhere, state register. The process contained herein unites right of possession with right to hold your property, trade name. Dulocracy, a government in which servants or slaves have so many privileges that they essentially rule. Also spelled dolocracy. Black 7, compare mixed war. Dummy, one who purchases property and holds legal title for another, usually to conceal the identity of the true owner. A straw man, sham, make-believe, pretended imitation, person who serves in place of another, or who serves until the proper person is named or available to take his place. Example given: dummy corporation officers or dummy corporate officers, dummy owners of real estate. Black 6, see note, dummy corporation. Note, your straw man is a dummy and serves in the place of another. You, when the straw man's trade name is called in court and you answer up, you become the proper person and are available to take his place and do. This is how the switch takes place. See in propria persona. Dummy corporation. Corporation formed for sham purposes and not for conduct of legitimate business. Example given: formed for sole reason of avoiding personal liability. Blacks 6. See note. Note, the United States government formed the dummy corporation identified as your trade name with neither your mother's nor your knowledge, consent, for the purpose of making you personally liable for repayment of loans of credit from the Federal Reserve. E.g., exempli gratia, for example, EID number. See note. Note, EID number is a unique numerical identifier bearing similarity with employee identification number and Social Security account number, just as IRS and state tax agencies denote the dashless SAN, example given 1, 2, 3, 4, 5, 6, 7, 8, 9, as the account number and case number We insert a single dash after the fourth digit and call it the EID number. Example given 1234-56789. Once you achieve standing as creditor over your strawman debtor trade name, you also acquire standing as employer because you, as creditor, are accorded the same standing as any other creditor. It is not unfeasible to consider your strawman's Social Security account number with a single repositioned dash as a unique EID number for you, the new employer. Employee. For purposes of this chapter, the term employee includes an officer, employee, or elected official of the United States, a state or any political subdivision thereof, or the District of Columbia, or any agency or instrumentality of any one or more of the foregoing. The term employee also includes an officer of a corporation. Internal Revenue Code 3401D, Subtitle C. Employer. For purposes of this chapter, the term employer means the person for whom an individual performs or performed any service of whatever nature as the employee of such person, except that 1, if the person for whom the individual performs or performed the services does not have control of the payment of the wages for such services, the term employer means the person having control of the payment of such wages. Internal Revenue Code Section 3401D, Subtitle C. Employee Identification Number, CEID number. Ens legis, a creature of the law, an artificial being, as contrasted with a natural person, applied to corporations, considered as deriving their existence entirely from the law. Black's Fourth, see note. This is a precise legal description of the all capital letters name, strawman trade name. Equity. A, the application of the dictates of conscience or the principles of natural justice to the settlement of controversies. B, a system of jurisprudence or a body of doctrines and rules developed in England and followed in the United States, serving to supplement and remedy the limitations and the inflexibility of the common law. Most generally, justice. Historically, equity developed as a separate body of law in England in reaction to the inability of the common law courts, in their strict adherence to writs and forms of action, to entertain or provide a remedy for every injury. The king therefore established the High Court of Chancery, the purpose of which was to administer justice according to principles of fairness in cases where the common law would give no or inadequate redress. Equity law, to a large extent, was formulated in maxims such as equity suffers not a right without a remedy, or equity follows the law, meaning that equity will derive a means to achieve a lawful result when legal procedure is inadequate. Equity and law are no longer bifurcated, but are now merged in most jurisdictions, though equity jurisdiction and equitable doctrines are still independently viable. Barron's Third, see note. Note, this is a very nobly described and apparently altruistic form of law and may have even been so at one time. Today, equity has much more insidious implications because it is founded entirely on the conscience of the court. In other words, literally, whatever the judge wants to do. See Admiralty law, Vice Admiralty courts, note at barratry. Escrow, a written instrument such as a deed, temporarily deposited with a neutral third party, the escrow agent, by the agreement of two parties to a valid contract. The escrow agent will deliver the document to the benefited party when the conditions of the contract have been met. The depositor has no control over a strawman in escrow. In common law, escrow applied to the deposits of instruments for conveyance of land, but now it applies to all instruments so deposited. Money or property so deposited is also loosely referred to as escrow. Barron's Third. Esquire, ranking immediately below a knight. Webster's Third, New International Dictionary of the English Language, unabridged, 1976. A man belonging to the high order of English gentry, ranking immediately below a knight, applied to various offices in the service of a king. In the U.S., the title belongs officially to lawyers, originally a shield bearer or armor bearer and attendant on a knight. In modern times, a title of dignity, next in degree below knight and above gentleman. Webster's Revised Unabridged College Dictionary. In English law, a title of dignity next above gentleman and below knight. Black's First. See the truth about esquires in Part 1, Section 2 of this manual for full expose. S, to stop, borrowing. P, to prevent, to preclude. Black's First. Estoppel, parties prevented by its own acts from claiming a right to detriment of other party who was entitled to rely on such conduct and has acted accordingly. An estoppel arises when one is concluded and forbidden by law to speak against his own act or deed. Estoppel is a bar or impediment which precludes allegation or denial of a certain fact or state of facts in consequence of previous allegation or denial or conduct or admission or in consequence of a final adjudication of the matter in a court of law. It operates to put party entitled to its benefits in same position as if thing represented were true. Estoppel is or may be based on actual or constructive fraudulent conduct, admissions or denial by which another is induced to act to his injury, agreement on and settlement of facts by force of entering into contract, concealment of facts, Black's Fifth, et sec, an abbreviation for ex sequentia, and the following. Thus, a reference to et sec means page first and the following pages, Black's first. Ex parte, one side only, by or for one party, done for in behalf of or on the application of one party only, Black's first. Fault in the civil law, negligence, want of care, an improper act of omission, an improper act or omission, injurious to another, and transpiring through negligence, rashness, or ignorance. There are 3 degrees of default. The gross, the slight, and the very slight fault. The gross fault is that which proceeds from inexcusable negligence or ignorance. It is considered as nearly equal to fraud. The slight fault is that one of care which a prudent man usually takes of his business. The very slight fault is that which is excusable and for which no responsibility is incurred. Black's first. And at this moment in time, we're going to stop right here at federal. What I would ask you good folks to do is to please like, share, and subscribe. Also leave a comment. Helps with the analytics. Please, folks, take the time to like, share, and subscribe. Like, share, and subscribe, people. Like, share, and subscribe. And be peaceful. Stay blessed and pray to pass God tests. And I will talk to you folks later.